Our topic for today really is an emphasis on what we have identified as a very serious difficulties for our community members. And it's in relation to providing false documents. We have identified some false documents in relation to Ghanaian marriage certificates, which is the statutory, the customary marriage certificate, and also birth certificate. This is very, very serious. And I say serious because the law, both the EU law and the British immigration rules, frowns upon production of false or forged document. So if you provide a false or forged document, then under the EUSS, paragraph 16, your application may be refused. Now, I use the word may because it's not mandatory, it's discretionary. What we have seen so far is that they are refusing all those cases where there is allegation of fraudulent birth certificate. So what happens is that you make your application to the Home Office. You then provide a birth certificate as evidence of your relationship with the EU national. They have evidence or some form of evidence which covers all those people who are eligible to sign the birth certificate. So once you've provided a birth certificate, they will compare the signatures on the birth certificate with the official records that have been given to them by the registrar in Ghana. Once they've identified concerns, they will raise this with you, and it's called minded to refuse letter. The minded to refuse letter is a recent occurrence which came about because of the case of Balagueri. So the case is Balagueri. Now, that case concerns somebody who produced false tax records. And although the law says that where allegations of false documents or false declaration is made against you, the burden of proof is on the Secretary of State to show that there's dishonesty. So if you genuinely make a mistake, and I will cite examples of what a genuine mistake is, then of course, that cannot be used against you. But for every document that you provide, you need to make sure that if it's an official document, that document is coming from the official source. And make sure that those people that you're using to source these documents for you are credible and trustworthy people that you can rely on. Because sadly, the consequences is very dire. We've seen cases where people have been refused under EU 16. The EU 16 simply means the production of false documents, misrepresentation, or false information may lead to refusal of your application. Just be mindful that once the allegation is made, the Home Office will give you time, normally 14 days, for you to respond to the minded to refuse letter. It's just like intention to deport, but this is called minded to refuse. So they will send you a letter, and the letter is called minded to refuse. That letter will say, "Dear so and so, we have identified serious concerns with the documents that you provided in support of your application. The concerns we have is that the signature on the document is not genuine. We have compared the signature to official records held by us, and we have concluded that your document is fraudulent. However, we have given you 14 days to provide reasons why this document was produced or why you believe it's not a fraudulent document." Now, first of all, most of the cases that we've seen are people who've already been given entry clearance or EEA family permit to come to the UK. So already the document has gone through the official sources and the British High Commission and the immigration who have passed it. And then once they get here and they apply for the 5 years, this is when the problem starts. And for me, most of the people that have come to us who've had these problems, who have then brought it to us to deal with it, are all innocent people. They will tell you that, listen, I relied on an agent to get me a birth certificate, which is what most people would do in Ghana. and the agent provided this document to me, I have no way of knowing that this document was fraudulently procured or that it's been tampered with, and therefore I am innocent. In law, we have something called actus reus, which is the mental element of a criminal offense or a dishonest act. So the Home Office also has the same standard. And there are case laws, the case of AA Nigeria, for example, those cases talk about dishonesty and that there should be a mental element of deception. So in your mind, your attitude is to use the document to deceive. When they come to weigh the document, they'll have to look at the relevance of the document to the application. For example, if you've provided a birth certificate, but your case is a marriage application, it's not a birth certificate that will allow you to stay here. It's a marriage certificate. And therefore, although your birth certificate may be fraudulently produced or a forged document, the relevance of that document to your application is negligible. And therefore, again, the relevance factor will ensure that it's not used against you. However, if you're relying on your father, your sister, your brother, your uncle, and you've provided a birth certificate as evidence of relationship, then as you can see, there is a strong correlation between the birth certificate and the grant of leave. And therefore, the relevance of that document is huge. Again, the seriousness of the offense. So for example, if you've provided a letter of support from someone to say that, listen, I know Bernard has lived in the UK for 2 years, and you've provided other documents to support that you've lived there for 2 years. Now, although the letter that you claim to have provided may be a false letter, yet the weight to be given to that letter will be negligible because you have other documents to provide who you are. In the same way, I can conclude that some people who have provided marriage certificates and believing the marriage certificate to be genuine, the same argument will arise that, listen, I'm not an official. I am not capable of determining what a genuine document is. And therefore, I procure this through the normal sources, which is that I went to the registry, spoke to someone who works there, and he is a person who procured it for me. And that is why I have provided this. If you're able to show elements of ignorance or lack of knowledge, that cannot be used against you, because the case of AA Nigeria says that where the Home Office makes an allegation of false document, the burden of proof lies on them to show that you had an element of dishonesty to deceive them, and that's why you provide a document. But we've all seen from this example that that cannot help. So what do? When you make your application, always check the source of the document. Make sure you're able to confirm that the document is genuine. 2, once you've made the application, if it turns out that the document is forged and they've given you an opportunity to respond, please, the first thing you state is that, listen, this is the allegation you've made. I have no way of knowing that this was a forged document, and therefore I have not been dishonest. I'm not capable of determining whether this is genuine or this is not. And please, give me the opportunity. I will provide a document to confirm the relationship. You can go back to the registry and ask them to give you an official biometric birth certificate that will confirm the relationship. If they go ahead and refuse your application, then you've got a chance to appeal. If you are in the UK, you have 14 days to appeal from date of receipt or date of decision. If you're outside the UK, then you have 28 days to appeal. The first grounds of appeal should be, if it's the EU case, is that the decision is not in accordance with the EUSS, insofar as it prevents you from coming to the UK or from obtaining residence in the UK, and that the allegation is not proven, and that the burden of proof is in the Secretary of State, and that you do not have the mind of dishonesty, and that your act is not a dishonest act. Explain why it is not a dishonest act. You procured it from a source. If you've got a receipt, most people will have a receipt. Provide a receipt. If you haven't got a receipt, why haven't you got a receipt? Explain. Who is this person? When did you get it? Have you seen such a document before? Do you have any prior document that confirms your details and the details of the other person on the document? Can you provide a DNA test to confirm that the relationship is indeed genuine? If you can do those, then clearly the risk of being refused or the appeal being dismissed at a hearing is negligible. But above all, once you've refused the minded to letter, please instruct a lawyer. Ideally, instruct a qualified lawyer and not a pocket lawyer. I know there are many pocket lawyers who listen to us, but this is far, far weightier matter because, again, it may lead to prosecution. Because bear in mind that the definition of false representation and false document, these are cases that have been determined in both the Court of Appeal in the case of Balagueri, which is a Court of Appeal case, like also the Supreme Court case is there, and the case of AA Nigeria. All view these cases as very, very serious cases.